July 2nd, 2014 zoning board of appeals meeting.
Motion to open meeting.
We got a motion by Kathy, seconded.
Seconded.
Dan, all those in favor?
Aye.
Well, welcome to the July 2nd, 2014 zoning board of appeals meeting. My name is Tom Wakefield, and on my immediate right is Kathy Franson, and then we have Dan McDonald, and then we have Mike Wood, he's an alternate member, and Bill Dunn is an alternate member, and we'll all be voting tonight. And this is Julie House, our ZBA secretary. And the agenda items are as follows. Under new business, do you have a letter for this? You don't have application 2007-2, White Birch Village 40B application. And this is a continuance of a 40B comprehensive permit for land located at 151 Center Street. Strawberry Fields under the direction of James Buston to construct 100 units under the Mass General Law, Chapter 40B. And it's my understanding that he wants to continue this till September meeting, which is, what's the date of September meeting? What is it?
That's what I was just. Third.
Third, okay. So it would be for the September 3rd meeting. And I understand that a purchase and sale agreement has been executed prior to the deadline on Monday evening.
It was signed by the selectmen the other night.
Yeah. Yeah. So this is a formality to keep his standing in case something happens and they don't go forward. So I make a motion to approve the continuance of the application 2000-2, the White Birch Village, until September 3rd, 2014.
Seconded.
Seconded. Dan, any discussion? All those in favor?
Aye.
Okay. The next application is 2014-8 made by attorney Rachel L. Junkins, Esquire, on behalf of Richard Greenwood of 863 Salem Street, to appeal the decision of the building inspector regarding 16 Nelson Street, lot 49, parcel 47-025, for not enforcing the Groveland bylaws, section 901.3 and section 905, and with respect to the above referenced property. And would attorney Rachel Junkins be here?
Good evening. Thank you, Chairman Wakefield,
Okay, no.
and the board for hearing us tonight on our application for this appeal. As you know, the building inspector has made a decision not to ask on our request for zoning enforcement in regards to the above referenced property. And I'm here on behalf of Richard Greenwood, who is a neighbor, but also Michael Tardy, who is an abutter of this property. Despite there being many ancillary concerns to this property and the building that was erected thereupon in 2010, there's two main zoning concerns that we have brought to the board's attention today that are basis of our appeal. The first issue is in regards to the property owner to obtain a special permit by this board. It is required under section 900 of the Groveland zoning bylaws that prior to obtaining a building permit, that a property owner has to come in front of the zoning board of appeals for a special permit. 16 Nelson Street is located both in the industrial district and also the aquifer protection district. And because of this location, any person who is looking to erect a new building has to apply for two special permits, one with the planning board, but also one with the zoning board. The zoning board of appeals could grant a special permit as required by 901.3 of the zoning bylaws, and the planning board could grant a special permit in the aquifer protection district as required by section 1700 of the bylaws. On April 28, 2010, the property owner of 16 Nelson Street applied for and also obtained on that exact same date both a building permit and an occupancy permit from your building inspector. Neither of these permits should have been issued at this time. My clients maintain that no notice was ever given to the abutters regarding the application for the building permit that is required by law. However, even if notice were to be given, the building permit should only have been provided by the inspector after he obtained the knowledge that the building would be compliant with all zoning ordinances and other pertinent laws. Section 108 of your zoning bylaws states that no building permit shall issue in any case where a building is to be erected, except in conformity with the site plan being endorsed by the planning board. At the point that it was applied for on April 28, 2010, when the building permit was issued, the planning board had not been petitioned.
Keep
I will
right
slow
there,
down.
good.
I speak very quickly, so
Yeah,
please
you
feel
do.
free to.
I do too, but just, relax.
That's okay.
Thank you.
Mr. Skeena's responsibility at that time was to ensure that the laws were being complied with.
Twice as fast.
And that included ensuring that the owner had obtained the approval of these special permits from both of the boards. The special permit granting authority in the industrial zone, again, is the zoning board of appeals, not the planning board according to your bylaws. The landowner had not gone before either the zoning board of appeals or planning board when the application had been submitted and that the building permit had been issued. And as you're aware, these special permits are necessary in certain districts to limit properties to specific uses due to the potential incompatibility of their characteristics of the district. The special permits are another level of formality over the building permits. On a side note, when you review the records provided by Mr. Skeena in respect to this property, the plans that were submitted with this property include plans for a building with the dimensions of 30 feet by 40 feet. We have obtained that from Mr. Skeena's records. The fire department, on the application for the building permit, specifically checked off that it would be only allowed the approval for a 30 by 40 foot building. This did not occur. The building as it currently stands is 30 feet by 60 feet. The building permit was approved notwithstanding the special permit requirements, and nor did it provide any specifications as to size. I have two separate building permits that I have in my possession right now that are in the record. One is a building permit that does not have any dimensions. The second one has handwritten in later 30 by 60 feet. Moving on to the occupancy permit that was given on April 28, 2010. This should not have been issued until the building inspector saw that the building, its uses, and all uses incidental thereto were in compliance with the town bylaws. No said inspection occurred, nor could it have on April 28, 2010, because there was no building. Sometime later, the owner filed for a special permit with the planning board. And on June 30th, 2010, the planning board, after a site plan review, issued a special permit for the new construction based on it being in an aquifer protection district. This was just one special permit that was needed. And as of this day, the owner of this property has failed and has not gone before this board to obtain the special permit for being in an industrial zone. Even Mr. Cammett, the town's engineer, wrote in his letter of June 23rd, 2010 on the site plan review that there was two failures in regards to the industrial zone. The first was that the industrial zone had to have a special permit by the zoning board. And the second was also the second issue that we have raised today in our complaint, which is the section 905, the setbacks for an industrial zone. Ultimately, the landowner moved forward with the construction of this building after receiving his building permit, the occupancy permit, and also the special permit from the planning board. The landowner erected a garage unit which occupies oil-filled delivery trucks for his business and has the dimensions of 30 feet by 60 feet, as I've already stated. According to the zoning bylaws in the industrial district, the building shall be set back at least 50 feet from the adjacent right-of-way line of a public or private way, and at least 25 feet on each side, or from the rear lot line. The lot in question that we're talking about actually abuts two rights-of-way, Nelson Street and Sewell Street. The lot itself is 60 feet by 110 feet, and as it stands, the setbacks from the rights-of-way are only 25 feet and only 15 feet from the sidelines. 25 feet back from both of the roads and 15 feet on the sidelines. Neither is adequate to meet the standards for the industrial zone as required by the ZBA. In review, the building permit and occupancy permit given to the owners of 16 Nelson Street to erect a building were given in advance of the owners obtaining of the necessary special permits. The owner wholly failed to obtain a special permit from this board as required by the zoning bylaws. And furthermore, had they appropriately come in front of the ZBA would have noticed that the plans for a 30 by 60 foot building would not have complied with the setback requirements. And of course, your engineer probably would have said so. The appellant has requested that the zoning enforcement officer request compliance with the zoning bylaws with respect to all of these issues. Now, the board is in possession, as I have submitted with the application, the correspondence that I have received back from Mr. Skeena regarding these issues. And I just want to highlight a few of the comments and concerns that we had. On November 22nd, 2013, his first response to me regarding all of these issues, Mr. Skeena failed to acknowledge the property does not have a special permit from the ZBA or that the setbacks were inappropriate for the district. On March 31st, 2014, after I had renewed my request for enforcement and seeking clarification of his first letter as to whether it was a denial to enforce the bylaws, Mr. Skeena responded by stating that he stands by his decision for a building permit. That is not what we were asking for. He states that 30 feet and 50 feet setbacks are adhered to. However, this is not a residential district. It's an industrial district and an aquifer district. On or about April 18, 2014, I received a final correspondence from Mr. Skeena, which provided some serious issues. He first provided to me that either the planning board or the zoning board would review a site plan. That's not the case here. Your zoning bylaws specifically state that both boards must issue a special permit. The planning board and the board of selectmen apparently did so in this case, but that is not printed from the record. Also, he states that he has the authority to make the final decision from town council on all of these permits. He further acknowledges that section 901, that the zoning board is to hear, he further acknowledges that in section 901 of your bylaws, that the zoning board is to hear the special permits, but that the planning board did so in this case. That does not comply with your bylaws. Your bylaws require, again, 2 separate special permits. Lastly, in his letter, he reaches the setback issue. However, from what he states, we wholly disagree with his interpretation of the setback issue. The bylaws specifically state that there needs to be 25 feet and 50 feet respectively from the rear lines, the street lines, the rear lines, and the sidelines. We now request that the zoning board request that Mr. Skeena's decision to not enforce we now request that the zoning board request that Mr. Skeena's decision to not seek enforcement of these bylaws and that the compliance of same be required by the owners of the property. Thank you.
Can we ask questions?
Yes, absolutely. Yes, absolutely.
Excuse me. The permit was issued, first permit was issued on April 28th
Correct.
on 2010.
Correct.
And today is July 2nd, 2014.
Correct.
Relative to the permit, there's I think it's 28-day right of appeal.
There's several issues we have with that. First issue is that the abutters will state, we have 3 of them that will state that they never received notice on the, they have never received notice that the building of them, on the building permit application. The only notice that was received by the abutters was when the planning board was summoned for a special permit. So this was actually, the building permit was given the same exact day that it was applied for. There was no notice given before it was given out.
But historically, are notices sent on building permit applications?
Yes,
To abutters?
they're required by the chapter 48.
You know what section it is?
I can grab it real quick. I believe it's section 7.
I have the bylaws. Do you know what page that is?
I don't know, I need to know.
Would it be section 7?
Of the Groveland bylaws?
No. I have 48.
I don't have, I don't have the text of 48 directly in front of me. I have the Groveland bylaws and also the manual.
Okay, I think it's section 7, okay?
apologize. I've actually misspoken. I apologize.
Yeah, I don't know that,
It's not required, there was case law that has stated,
Yeah, I mean, I know that
stated
there
that
are-
it would further support the applicant.
Yeah, I-
If there were ever an appeal of their building permit, it would protect them in a
yeah,
case
I
of
know that
license.
in some municipalities
That's required.
that I've worked in, it was required, but in a different state, so, even when I worked in New Hampshire, it wasn't required, so, but it does, there are some provisions in 40A, Section 7, which is probably pertinent to what we're talking about here.
Right, correct.
Any other questions?
Yes, at what point in time, first of all, I mean, the issue before us, I see is one of jurisdiction. If the appeal is untimely, then if there were prerequisites were not met in issuance of that building permit, well, we don't get to that point if the appeal is untimely. The zoning board of appeals lacks jurisdiction to hear untimely appeals. And chapter 48, section 7, as my understanding is a 30-day appeal period. There is case law on point that requires a duty of inquiry. So what knowledge did the abutters or the aggrieved parties have that that building was erected?
The only time that the abutters received notice that the building was erected was when they heard that it was happening. And they came down and received that first building permit that did not have the dimensions of the building.
And what point in time was that?
That was
That was
shortly thereafter. It was before the planning board had met because we believe that the dimensions were written in after the site plan approval. However, there's also a 6-year
And
statute
that
of
was in the year
limitations for building
2010?
permits. That was in 2010.
Why did they wait 4 years to come before us?
There has been a long line, as Mr. Skeena will say, of correspondence trying to get him to enforce these issues, and he has skirted around it for a very long time.
No, I have seen, I've seen a letter from Mr. Skeena, I don't know that it's in this particular package, that was written relative to this particular structure, and at the time, the gentleman who received the letter, I talked to, I'm not sure if it's the same one here this evening, was aware of it, and I told him that he had 30 days to appeal that particular letter, which was written very, very close to this date here, and that didn't happen. We'll get to you, Pat.
Our position is that there's a 6-year statute of limitations on the building permit.
Now, what do you mean by a 6-year statute of limitation? Can you explain that?
Sure, there's a 6-year statute of limitation for building permits that are issued for non-conforming properties. It's,
Are you getting that out of 40A?
it's out of case law that has come down, right here. 48, section 7, sentence 2, clause 2 states that real property has been improved and used in accordance with the terms of original building permit issued by a person duly authorized to issue
Could you
such
slow down,
permits.
please?
Okay, you gotta talk a little slower.
You got old people behind
It's
you.
okay.
You can talk faster.
Chapter 40A, section 7,
Yeah?
footnote 2, sentence 2, clause 2, states that where property has been improved and used in accordance with terms of the original building permit issued by a person duly authorized to issue such permits, no action, criminal, civil, the effective purpose of which is to compel the abandonment, limitation, modification to the use of said permit shall be maintained unless such action or suit is commenced with notice thereof, recorded. If you look to the bottom within the last sentence, within 6 years after commencement of the alleged violation of the law.
That's why they stopped publishing building permits in the newspapers years ago when this precedent overtook the
Excuse me.
30-day appeal period.
You can't speak unless you get acknowledged. Thank you. And so the basis of the appeal is you're saying that within 6 years of the issuance of the permit, a person withstanding can appeal that
Correct.
decision of the building permit?
Correct.
And are we talking about the building permit for the structure or for the use of the structure and the setbacks of the structure? Or are we talking
For
about
all
all
of,
three?
it would be all of the above. I mean, they're all under the building permit. The building permit should not have been issued until the proper special permits were obtained. They were not, when the building permit was issued. The building permit was issued the day it was applied for. The occupancy permit was issued the day it was applied for. There was no building on this property the day it was applied for. So in order for a building permit to issue without the special permits would imply that the zoning enforcement officer didn't make sure that it was in compliance. Now, the other issue, which you can see from Mr. Skeena's records, is that the plans that were submitted in the application for the building permit has drawings of a building that's 30 by 40 feet.
Yeah, I don't think we got that.
We obtained that from the town some time ago, and I do have a copy.
Yeah, I don't
We
know.
didn't get it in our packet.
Yeah, I don't- yeah,
So I was wondering that, so.
yeah, I don't have.
I would like to, I can
I
get
have
a copy
plot
to you as
plan.
well then. I believe it's Mr. Skeena's record, but I can show it to you if you'd like,
No.
Mr. Chairman.
Yeah, I don't have a plot plan either.
You don't have a plot plan?
No. All I got here is the town of Groveland permit to build, and then it says garage for storage, and it says 30 by 60, but it does appear that may be of a different ink pen at 16 Nelson Street.
Right. My clients had obtained the original permit once they had heard that the construction was going to commence and go in front of the planning board. They came down, got a copy of the building permit, didn't have dimensions. Later on, we get another copy, there's dimensions, and it says 30 by 60. But the plans,
Do you have the MGL book there? Can I take a look at it?
here you go. Chairman, there's also the site plan in the 30 by 40. And here is the statute of limitations that says it's bifurcated. Respectively, you get 6-year statute of limitations when it's based on a building permit that's properly given, and then 10 years when it is not.
I see the 10 years. Trying to see what it says 6.
It says 6 years for the use and then 10 years for the structure.
Is this the first appeal or attempt to appeal? Because the only time we had someone sent a letter and came in and talked to the board, but there was never a formal.
There's never been a formal
So
appeal.
is this the same person that came before the board before?
I can't speak to that, honestly.
Is your client here?
They're both here, yes.
Could we ask him if?
Not that I know of, not that I'm aware of anybody.
Did another attorney come in front of the board at any point in time? No.
No, did Mr. Greenwood come?
No.
No. Okay, so there was someone else that was questioning the same thing, but it was a different party, but it never went beyond a letter that came to the board, and we told them that we didn't have jurisdiction unless they.
I believe what you're referring to, I might have seen it in my client's file, is a letter from attorney William J. Barron out of Haverhill that, who asked for the enforcement, and when it went nowhere, I think that they didn't bother filing an appeal at that time.
Yeah, that was a couple of years ago.
Might have been 2011, maybe
Yeah.
2012.
Still looking at
Yeah, we'll take a quick make a motion to recess for 5 minutes so that we can research this here.
Great.
Second?
Second.
Second, all those in favor? We're gonna just,
Thank
we're
you
gonna
very
look this over, we're gonna check, thank you.
Thanks.
03, I make a motion to reopen the meeting. You all set, Charlie?
Second.
No.
A second by Kathy, all those in favor? Okay, we got a couple of questions. The time is, the issue of timing, to me, is a problem. And I think that the 30-day time is a real issue. However, we don't have a site plan. The one you gave us doesn't have a site plan. You're saying that the building is closer to the property line than required in our ordinance, which is 50 feet from the adjacent right-of-way and 25 from the side, but this package here doesn't have site plan.
Correct.
Neither does the one you gave us, doesn't have dimensions.
Correct. Respectfully,
What was submitted with the permit, you see, I mean,
What was submitted with the building permit?
yeah,
Was was what I just gave you, that building right there. The 30 by 40, that was submitted with the application.
No site plan?
there's no setbacks on this.
It doesn't have setbacks, it's just 30 by 40. That's this one that was given to us. I had an extreme issue in the past few weeks with gaining information. And if that's what we're lacking here today, we might have to continue this for 30 days to obtain all the information to get it in front of us. We've tried to contact Mr. Sorensen and he has not been in touch to obtain that site plan from the planning board, because I believe that's who would have it at this time, because they were the ones who gave the special permit based on that
Well,
site plan.
as I see it, the use of the garage for storage, it doesn't state what the storage is. What is, Brad, what is his
Paralegals?
name?
It's an oil company.
He runs an oil company?
He runs an oil company, and right now there's, I believe, what the permit was given him was 2 trucks, or, excuse me, the Cameron Engineering, I believe in their letter of June 23rd, 2010, states exactly what the use was for. I can give you a little bit of an idea. It was the storage of 2 trucks that would have over 2,000 gallons of oil in the property. And that was what it was supposed to be for solely.
That's not on the building permit
That is
application.
not on the building permit. It says, okay, second page of the application for the building permit.
8,800 gallons right there.
For storage only, 8,800 gallons or less of fuel oil.
Yeah, see, we don't have a copy of that.
We
either.
don't have a copy of that.
I apologize. Oh, she's getting all of this.
Well, we're gonna review this. Is there anyone else here this evening that wants to comment regarding this permit? If you do, give your name for the record, please, and then you can comment.
Yep, my name is James Dole, Uptack Road, William, Mass.
Yeah.
Sat on the zoning board up here for 11 years, and I'm off board this year. I've seen a lot of things come through this town on the zoning board, and as an assistant building inspector for 10 years prior to that, I filled in other communities also.
Are you in the butter?
No, I've been asked to help. The
By whom?
applicant here tonight, I'm here to help the
Okay,
applicant.
you're assisting the attorney?
He's assisting the applicant.
The applicant, okay. And you're the applicant?
Yeah, me and Mike.
Okay.
And I'm not here to critique the process or
Yeah.
belabor any of this. My question would be is, and it takes years to learn a lot of this stuff, do you guys understand what an aquifer is and how it functions?
Hold on, let me just give you an idea of what I do know.
I understand
Don't
your-
insult me, I've got 30 years of code enforcement, and yes, I know what an aquifer is.
How about the rest of the board and
I don't know.
the community, while the camera's on us, so to
Yeah.
understand wholly, what's happening here tonight isn't just a mincing of days, it's our aquifer. We had a Superfund site 35 years ago, 2,000 gallons.
Hold on, yeah, I don't
I'm
really
not
want.
way off,
I don't
I'm
need.
right
I-
on point. I'm
Yeah,
not
no,
ex-
you're out of line, sit down, please, okay? We're not gonna talk about aquifers, we're here to talk about this here, okay? I understand it's in an aquifer, and we'll discuss that, okay? We don't need to be.
I beg for 5 minutes.
I don't need to have you tell me what an aquifer is. I have 30 years' experience, so I don't wanna talk about it. I can explain to the board as chairman. What else do you have to say?
Understand, we have an aquifer bylaw in place. It's under 1700, section 1700's requirement.
I understand that. Now, what do you have to say about the building permit that is being appealed here this evening?
The reason,
The building permit is actually not being appealed this evening.
What is
It's
the,
the decision of the zoning enforcement officer that was not enforcing the zoning bylaws that are not being complied with today.
yeah,
A building is in place that does not have a special permit by the ZBA, and it does
Yep.
not have the proper setbacks in the industrial district.
but as I said to you earlier, I'm not so sure that the 30-day.
Could I ask you?
Go ahead.
I'm gonna read it here, timing and jurisdiction, and I wanna clarify this, because this is the crux of the issue before we proceed with any issues on any merits about what wasn't done properly. Administrative appeals are governed by the terms of Mass General Laws, Chapter 48, Section 15, which provides any appeal under Section 8 to a permit granting authority shall be taken within 30 days from the date of the order of decision which is being appealed. The reference to MGL Chapter 48, Section 8 to permit granting authority places jurisdiction in two possible arenas. Mass General Law, Chapter 48, Section 1A defines the permit granting authority as the Municipal Board of Appeals of the zoning administrator. So, you know, I ask you, Counselor, is your interpretation of the 6-year statute of limitations, the statute of limitations to commence a suit, or is it to appeal to the zoning board of appeals? Because my interpretation is you have 30 days to appeal the permit decision of the building inspector.
Not the permit decision. We have 30 days to seek the review by the board of his decision not to enforce. When a request for enforcement has been asked by the zoning board, that doesn't matter if it's a week after the permit, 4 years after the permit. We ask that the non-compliance that continues today on that property be enforced by the zoning enforcement officer. That was not done. Within 30 days of him clearly stating that he wasn't going to do so, November 15th and again in March, he completely ignored the issues we were requesting, saying that the building permit was given and that's it. He didn't have to do anything else. He finally stated that he didn't agree with the setback requirements. He finally agreed that he didn't agree that the special permit from the zoning board was ever needed. That is when we filed this within 30 days of receipt of that letter. That is the 30-day period under Section 615 and Section 8 that we are here on today.
Now, the underpinnings of your argument is that the building permit should not have been issued, is that true?
Not the underpinnings. The underpinnings is that a special permit should have been sought by the Zoning Board of Appeals and granted prior to.
The underpinnings being the prerequisite of the issuance of a permit, is that true, that they were the prerequisites of issuing the building
They
permit?
absolutely are prerequisite. It was
And the
special.
building permit was issued in 2010, and it was not appealed within 30 days of the issuance of the permit, is that true?
That is true.
Is that
How,
true?
how is any abutter supposed to know about the issuance of a permit when it's not being notified until the planning board is being requested for a special permit some 60 days later?
Under case law, there's a duty of inquiry. If they have adequate notice, okay? They had some notice. They had notice of the planning board review, is that
That
true?
was June 23rd, so that's 60 days later. 60 days later, they received notice
Well,
about
yeah,
that.
but they had
In
no.
what year, ma'am?
2010.
In 2010.
This is 2014.
So they start the clock running 30 days from that
No,
notice?
absolutely not. At
Why
any
not?
point, if I walked up tomorrow and I saw a property that is across the street that is out of zoning, I could ask the zoning enforcement officer if I was aggrieved by that. A person aggrieved by that zoning, by that zoning ordinance not being complied with. I had standing to request that it be enforced. If he says no, I have 30 days from the point that he says no to come in front of the zoning board or whomever, which board needs to be brought to. I have 30 days from his decision not to enforce to come before this board, and that is what we did.
I'm gonna read one more citation here from your law book here, if you don't mind.
Sure.
The 6-year statute of limitations protects a use allowed by said permit in a structure erected in reliance upon said permit.
Correct.
Okay? A use is protected from actions to compel its abandonment, limitation, or modification. A structure is protected from actions to compel its removal, alteration, or relocation. To come within the statute of limitations, there must have been a building permit. Was there a building permit?
There was an illegally obtained building permit.
Was there a building permit?
There was a building
Was.
permit. There was no
Permit must have
notice
been
of
issued
building
by a
permit.
person duly authorized to issue such permit. Was the permit authorized by the person duly authorized in the town
Yes,
of
he was.
Groveland? The real property must have been improved and used in accordance with the terms of the original building permit.
Don't know. There was no size on the original building
If
permit,
you don't know why you're here,
because it was written in afterwards.
I think you're time bound by the 30-day appeal.
I don't
period,
believe so.
and I rely on the Anino case, which is an SJC case, and there's a statute on point, it's 30 days, so.
It's 30 days from the building permit. As far as the building, to this day, being non-compliant.
There's a public policy behind a statute of limitations. And part of that is that if you know about something, a prudent person, a reasonable person would act in a reasonable period of time. If you see something erected next to you as an abutter, you can't close your eyes and become blind to that action and then let the clock run and let the property owner run up his costs into thousands and thousands, maybe tens, hundreds of thousands of dollars. So it's a
And you
balancing of.
continue to read that book,
So
one
it's-
more paragraph.
It's a balancing of the rights between the property owner and the other, abutters and the, people that have standing. And there is a statute of limitations because that you have to make a timely appeal. If you do not, you waive that right to appeal. I don't see that your client's, timely appealed this matter.
If you continue to read that book, within 2 paragraphs, it says that property owners are not protected between a laches claim or equitable salvable claim within those 6 years or within the 10 years from the bifurcated statute of limitations. That's exactly what it says. There's a 30-day statute of limitations from the point that Mr. Skeena said, I am not going to enforce these zoning bylaws, the zoning provisions. There's 30 days from the point that he said, no. We're within that 30 days.
We disagree. It's 30 days from the issuance of the building permit.
Okay.
That's what case law supports.
30-day appeal must be better for this then.
You can argue.
Well, let me, let's bring Pat, I want to just ask Pat, his.
Absolutely.
If we could,
Here also.
yeah. And then we'll go to the planning board. Want to come up, Pat, and tell us what happened?
Yep. Never once has Mr. Greenwood come into my office, send me a letter, or complained about this building. He's had 2 other attorneys that we've sent all the documentation to, and once they seen and read it in the appeals period that he didn't answer, they just never did. This is the 3rd attorney that's worked on this case. These are the plans that were approved for the building, signed, sealed, everything. It tells you the size, 60 by 50, which is there now. As far as the setbacks go, the road is not the road is not 40 feet. The road is not 1,000 feet long, like on the town maps. If the road was the width it's supposed to be, Mr. Greenwood couldn't keep any of his cars where he keeps them. The original toxic waste, batteries, tires, all kinds of things, originally came from Greenwood Auto Body before he owned it. They cleaned up that site at, I don't know how much, a dumpster after dumpster. I saw the batteries, the oil, the tires, and everything that was dumped there. Martin Buildings put up a state-of-the-art building that is fireproof. I mean, it's a beautiful building. And Brad houses a truck in a garage. It's empty when he picks it up. It's empty when he brings it. That's all. There's no phone there. There's no advertisement. Nobody works in this garage. He picks the truck up, fills it up with the amount of oil that he has orders for, delivers it, and brings the truck and parks it there in a fabulous building. I don't know what the.
1 truck or 2?
Pardon?
1 truck or 2?
One that I know of. Brad, do you have 1 or 2?
There's 2
Okay.
Brad Legals, there's 2 active trucks in there, and I have a backup truck, just in case one fails.
With a
Okay.
self-contained foundation.
And we built it for containment.
Okay, I just was curious about how many trucks.
Okay.
Thank you.
Pat,
Area is subject to flooding also.
Pat, in 905 of zoning ordinance, it does say that in an industrial district, and looking at our map, it appears that this is indeed an industrial zone.
Yep.
The setbacks, 50 feet from the adjacent right-of-way, a public way, a private way, excuse me, and shall be at least 25 feet from the side lines and rear lot lines. Now, this here shows that it's less than that.
Yep.
So, how did you square that?
Originally, I did tell Brad, garages are usually 30 from the street, 15 and 15. That was my mistake. I made that mistake. That's what I told him, and that's what he went by. That's, I don't know what else to tell you.
But there's it was issued in violation.
Pardon?
It was, it was issued in violation of our ordinance.
Right.
When did you discover that?
Later on. I
How
don't
later?
have the date, but it was later on.
Have you ever,
It was
construction
after the
done?
building was built. It was after the building was built.
it wasn't soon enough to issue a stop work on it?
The building was all completely done and all that.
Because it appears that the building currently, as it stands, is in violation of our zoning ordinance, and it does require a variance to be there.
I wouldn't be against you people ruling that he comes in for a variance.
Yeah, I mean.
I have no problem
Because
with that.
it's very clear. Now, the other issue is, and I didn't look at it real clearly, but I am very, very familiar. The town I worked with in Brunswick, Maine had 3 aquifers, 1, 2, and 3, depending on the
Right.
use and the severity of it. So I have been involved in obtaining, even to the extent of a body shop that relocated in an aquifer. So I am intimately aware of how sensitive aquifers are, but I also know that things can be done if they're protected
Yep.
properly. And so, what type of protection was built into this particular system in case of any overflows or leaks in regard to these buildings?
He does that, the trucks leave empty and come empty. He picks up the.
Well, you know, Pat,
Okay.
I gotta tell you,
Yeah.
the road to hell was paved with good intentions, but
Yeah.
my experience over 30 years of code enforcement is that
Right,
it doesn't always work that way,
okay.
you know?
I don't go there and check the trucks.
Yeah,
That's what I'm told.
yeah.
Can I ask a
Hey,
question?
Go ahead.
Tom?
Was it your understanding when you issued the permit that he would be storing oil trucks?
Oh, I knew that. I knew he was storing trucks, yeah.
Oil trucks.
Right.
Has that changed since?
No, not that I know of.
Tom? I heard someone in the audience, oh,
Go ahead,
Okay.
go ahead.
I heard someone in the audience a few minutes ago state that that building was built, I don't know who it was, but they said the building was built, you got questioned, and I don't think heard it. It was built to contain the oil or something, I heard someone
I
say
did
something.
hear that, but
What's
I
that?
was hoping, I did hear that, I was hoping that the building inspector would tell me that.
Okay, sorry.
And I said the area is prone to flooding after that, because it floods.
Now, in addition to the fact that 905 setbacks are an issue, this particular use would have required a special permit as well.
Well, as far as I know, the planning board issued a special permit.
Yes, it wouldn't be the planning board, it would be the zoning board of appeals.
Well,
But if the planning board went ahead and issued the
This
permit
guy works
prior
for the
to,
town of Groveland.
prior to,
Are you
if the
kidding
planning
me?
board went, if the planning
You're out of
board,
order, okay?
if the planning
Sorry.
board went ahead and issued a permit before the zoning appeals, we need to hear from the planning board, and that's why I asked that we have.
We're gonna.
What's next?
That's next. We're just trying to,
Yeah.
So, when the gentleman came in with these are stamp plans, I see, from the Morton building, I'm familiar with it.
Yeah.
And then you had told him prior, that the setbacks are 15 and 30 inadvertently.
Right.
And then you issued it based on that.
Right.
But and when you realized the difference, you.
it was way too late. It was way,
But you never, you didn't bring it to his attention that,
Right.
we've got
yeah,
a problem with these setbacks.
yeah.
Okay.
Mr. Chair, may I submit some documents to you, please?
Yeah.
The first one is from Kaufman and Page. It gives distinct, exact procedures to follow under aquifer bylaws, special permitting review processes, et cetera, and it affects this review tonight, especially when it comes to the aquifer. And there's a case law that we were sued and won in court because most people that come and build in town and they don't come and do the proper procedure, special permitting from the zoning board, they circumvent the right for us to know what is actually going on with the property. Town
Well,
council.
hold on. I agree to a certain extent, except that this building was built between two people. And I can tell you right now that the minute the excavation started, they knew there was a building being up there. So don't stand in front of me and tell me that the people weren't aware there was a building going in there, because.
I agree.
Like I said,
I agree with that.
I've worked in this for 30 years. I worked when we were in a situation with, we had 42 miles of shoreline, in Brunswick, Maine, which I was a code enforcement officer in, and the minute a chainsaw started, I got a call. So if there was really concern about what was going on there, as soon as the excavation started, and if you look at the plans, there's a 4-foot frost wall under that thing, then guess what? They were aware that there was a building going on,
I don't
probably
disagree.
somewhere close around April in 2010.
I don't
And
disagree.
We're all set. Go ahead, Pat.
Oh, yeah.
Pat's got the floor, excuse me.
Yeah, I just wanna show you this, that the planning board does have the authority to issue a special permit.
Yeah, that's right, but that's not that's relative to the aquifer.
Okay,
And that should have been done prior to the building permit being issued, was that done?
yep. No, no.
No, okay. Okay.
Mr. Chair?
And so, there's two special permits, a special permit for the use.
Right.
As a commercial building in
Yeah.
an industrial zone, which I
Yeah.
looking at, probably was, the use was appropriate. But then, the aquifer protection ordinance requires that a planning board reviews the site
Right.
plan to see that the use is gonna be protected, so that any
Right.
type of drippage or
Right.
spills
Spillage
would
or
not
anything like
affect the
that.
aquifer.
Exactly.
So
Right.
that should have been done prior to the issuance of the building permit.
Yeah.
Okay, so two things happen. I think, without a doubt, there's a setback issue that has to be addressed, and, you have anything else?
Do I?
Yeah.
I mean, until you determine whether or not ZBA has jurisdiction, I don't believe we go to
Well,
the
yeah.
merits of whether or not there were any defects in the issuance of the permit. They
Well, I
come-
think-
They come to moot after the appeal period lapses.
Well, except that when the applicant brought notice to the inspector that the setbacks were at issue, and then 30 days from there filed an appeal to the setbacks under the 6-year provision, then probably that particular aspect. And in fact, I'm surprised that the gentleman, if he ever refinance, tried to sell, wouldn't have an issue with setbacks because they're in violation of the ordinance. Period. You know, so I think that the board has jurisdiction on setbacks. The use, I mean, that should have come, it didn't, I'm not sure that we have any use of, any recourse on that particular.
The dimensions of the building,
Yeah.
it was built.
Yeah, I mean, but thank you very much, Pat.
Okay.
We're gonna have a
Yeah.
planning board,
Mr. Chair, you cut me off before I could
yeah,
finish my
hold on,
comment.
hold on. We got the planning board's gonna speak. You got someone here from the planning board to tell us?
Yeah,
what happened to the
Jim
plan?
for your, Groveland Planning Board. We did have a site plan done by our engineer. We did have the aquifer approval done as well. What always gets us about the aquifer is the whole town's an aquifer. It either flows to the Merrimack River or it flows to the Parker River. So there's no degree of difference whatsoever at all anywhere in the town, whether this part of the town is more stringent than this part of the town. Very hard to understand sometimes. That aside.
How long after the building was up, was it
The building
before
was not
they came
up.
to you?
The building was not up.
It was not up?
So, and the problem becomes one of the way this whole thing really should work is once approval is given by the special permit granting authority, somehow, some way, in that approval, it should say, go to the planning board and get a site plan approval done, an aquifer approval done. That's what we need to do. Now, we used to have a sheet that everybody signed off on, that basically saw the situation and therefore could offer comments. It's there, it's not there, but that probably ought to come back. It takes a little bit extra time, but
Well-
it does stop problems.
In the approval process, in the past, when we've had approvals, they've always been subject to any other jurisdiction within town and Commonwealth. So that's been covered on our part in the approval that's recorded, so that part's taken care of, but you said that this was in fact, before the board, the planning board prior to the building going up?
Bob O'Hanlon, planning board. You should have some documents from the water and sewer department. When we did the site plan review, they were instrumental in that. We wouldn't sign off on anything until we got their input on the water market plan. That was part of the procedure. So there is a letter on record, and I believe Pat Scanlon has a copy of it. Yes, I do. What they did approve for. And they knew that the oil trucks would be in there. But the building, as far as I know, wasn't up at that time because we hadn't finished our process.
Now, can I ask one question?
Mr. Chairman?
Go ahead.
I'm sorry. I want to ask Mr. Hanley the question.
That permit specifies 8,500 gallons.
Yeah, or less.
It's 88.
Oh, I think it's 88.
88?
Yeah.
Quick question. The building that you guys had on the one that you approved, what size was that building? Do you know offhand? Because we have your copy of what you had.
I've been searching through our records and I'm still looking for the original plan. And supposedly it should be recorded at the registry of deeds too with the memorandum of receipt that we wrote on that.
Yeah.
Can your board oversee ZBA and go ahead and issue a permit for a building that doesn't meet the side setbacks? Can you, with that special permit,
If it
does that
doesn't meet
special
the-
permit over supersede this board?
The zoning bylaw distinctly says who's gonna be the special permit grantor.
So your special permit basically was just for the aquifer
Well,
end of the
yes.
permit?
I mean, the zoning board has the ability to give out variances as to setbacks, you know, front, side, back. But, you know, what has been discussed tonight, what's hitting me over and over again is, it's 4 years later.
Right.
Building's occupied. It sounds like it's one of those uses that's not causing a problem to anyone. And grants us tax monies. So, you know, it's, when I look at the world of what we can get into, I look at this situation, I say, if I got my druthers, I'd druther this. Maybe things weren't followed correctly. And that may be a problem. I don't know whether to say maybe the Board of Appeals, or the applicant, or the person who owns the garage ought to appeal to the Board of Appeals for waivers.
At the end of the day, we spend here all night, we can hash this thing back and forth, and I understand there's two parties involved.
That's where you're
What can
going.
we do to find common ground? That's where I'm at.
Can I just say one thing? Mark McCabe, I'm the one who built the building with Brad. It was called McCabe Legal Realty Trust. I built it we built it in 2010. We got the permit. They said to Brad, we gotta go through all the right things if we're gonna do this. Myself, didn't wanna build it, actually, I just wanted to hold on to it. But we built the building. We asked Walter Sorensen exactly what we did. We went through planning board, we paid a lot of money for a site plan review. We did everything that everybody told us to do. Kendall Construction came in, we went through conservation, put a pipe in, we did everything. We cleaned up all that mess that was there, cost us thousands of dollars, and we put up a state-of-the-art building. And then the reason why we're here now is we got along with Greenwood through the whole time. It was all a matter of the reason why that private road, his cars were parked, we were going around them. This is why we're here now. This fight is over parking. It's not over. He liked us. We got along for 2 years. It's all because of the parking now. There was no problem before that. I just want to clear that up. And I sold the building 6 months after that. And just in case anybody knows, because some people think that I still own it, it's still called McCabe Legals Realty Trust. I leave myself as the trustee, and he just left it at that name, just so you wouldn't have to change, you know.
My point,
Mr. Chairman?
okay.
Go ahead, Bill.
My point again will be, in me, I always try to find common ground. I understand what Mr. McCabe just said, that there's a fight going on, there's a battle going on. I know, I'm basically kind of friendly with them all. I know them all, we're all town people, we all live together, we need to work together, and what have you. my thing tonight would be to try and come up with some common ground on this. I know there's some issues about parking, but I realize there's legal issues, and I'm sure the parties in front of us probably want to, proceed, but I mean, I would like to see it to try to come to some kind of a common ground situation with them.
Well,
and see if we could.
Mr. Dole, it's clear that the building, the applicant went before the planning board to review your concerns of the aquifer, and as stated, the planning board reviewed that building in reference to aquifer, and from what I'm hearing, approved that particular site and building as the plans were submitted. I see, the only issue I see, Bill, and all due respect, Ms. Jenkins, is the setback issues, and I think those aren't gonna go away. There was a mistake made. I can't say I never made a mistake, but what you do is when you recognize it, you quickly say, hey, we got a problem, I made a mistake, we gotta get to the Board of Appeals to try to get some relief here. So it appears that the use is a permitted use. I think it probably should have come before the zoning board of appeals for a special permit as well. It didn't. I think that the 30 days happened in this. So it appears to me that the only issue that the board would have any jurisdiction this evening on would be the setback issues, and we could require the applicant to come before the board to try to seek relief on setbacks from 50 feet to 30, and then from 25 to 15 as submitted and approved.
Mr. Chair, that court case that Groveland became the defendant and was settled in Groveland's favor specifically states that self-created hardships are not warrant for a variance.
Listen, I didn't say that anyone's gonna get a variance, I'm just saying what has to happen.
Now, the aquifer bylaw is explained by town council that it's a two-part review system. The zoning board of appeals shall administer, which means will, and then it goes to the planning board for the engineering review, and then comes back to the zoning board of appeals on the aquifer bylaw review, because the aquifer bylaw, it needs a variance if it exceeds a 15% of coverage on a lot. When you take the coverage on the lot, you take the size of the building, the 300 square feet for each parking space around the building with a 10-foot setback, which is in the industrial zone, they can't meet any of that. It's a gross dereliction of duty, and I think they probably had a hunch that they probably wouldn't get a variance because you just couldn't do it. The special permit review is an oil business, it's a hazardous chemical, and if it floods our water supply, we're in trouble. And that's what the special permit review is about. So when a zoning board writes a special permit, it goes to the registry of deeds, so the public can be aware of what's happening here.
Wait a minute, hold on. Jim,
Yeah.
planning board, do you have concerns with after reviewing that building, do you have a concern on that?
No, because our engineer passed on it,
Okay.
and so did the.
That's addressed, so, I mean, really,
So the
come on.
water
By the
sewer.
zoning board, that's what our section 19
Well, yeah,
requires.
but we would not have done that review anyways. That review jurisdiction right here is under the planning board jurisdiction.
In order
we would not
to
have
obtain
reviewed the
a building
aquifer.
permit in industrial zone, which we are in speaking about
That's
tonight,
right.
requires a special permit from the zoning board. There's no
That's
other
correct.
caveat available. And when people like this don't get notified from the zoning board of appeals for special permit review, they're left out in the dark. All this other nomenclature, and he said,
Hold on,
she said,
listen,
nothing
Jim,
but smoke and
hold on.
mirrors. And I question if it's a
Don't blow
public
smoke,
official.
please. Don't blow smoke at me, okay?
I'm not. That's the
When
last thing I have
when
in
that
my
first
mind.
excavator came down that street and dug that hole, those abutters on either side knew that building was going in there. So don't sit here and blow smoke at me, okay?
Before
That's
shut
enough.
Mr.
You have
Mr.
to shut
Chairman,
off.
never
notified about a permit.
Yeah, please.
Mr. Chairman, can I ask some questions as to
Yourself on the ground,
Go ahead.
going to the zoning board.
That's enough. That's enough.
Mr.
I'll ask you to leave.
O'Hanley, you're on the planning board. You were back then. Can you, for those of us that don't know, what is the notice requirements when people come before you with a site plan for review?
The applicant has to send out the green card certified return receipt. And it has to be published in the paper twice within 10 days. And we were down there cleaning all the debris up. And there were calls going back and forth by the neighbors. They knew that that building, that property was going for a hearing and a site plan review well in advance. There's no way that they didn't know about that.
Okay. So they had actual notice. More than-
Yes.
But after the permit.
Planning board would give
No,
lots of
the building permit was issued, but the review was done
2
before,
months later.
before the building went up.
I understand that.
Correct.
It
No, I
appears
hear
to
you.
me
I'm
there were a lot of
down the timeline, that's all.
procedural
There was
defects.
a, yeah, but.
But the time to cry foul.
Yeah, was
within-
back then.
Within 30 days of the issuance of the permit.
And no one's gonna sit here and tell me that.
And that's
the minute
the
that
law.
thing- Yeah, the minute that excavator was down there digging, that no one knew there was a building there. Please, okay, save it for someone that's naive here, because.
You wait 4 years
Yeah.
and you prejudice the property owner building I don't even know what it costs, but X. And that's in the interest of equity and fairness. That's not fair, and that's why we have a 30-day appeal period, and it wasn't acted upon. Notice of the site, a review was given, the several permits. There's detail on those permits about the number of gallons, oil specifically. You know, I have a lot of problems with waiting 4 years to cry foul on this issue.
Yeah, I agree with it, except that I do, you can't, you can never grandfather an illegal setback. I mean, those need to be remedied, and whether or not that can happen, I don't know, but, you know, you issue it and it's wrong, it still doesn't make it right. Never does.
But you can't unring the bell, the building
Well, no, but
inspector issue the permit.
what
the
has to
building
happen
gets
is
built.
someone has to convince the Board of Appeals that they need to get relief on the setbacks.
And what if they don't?
Then there's an issue.
Tear down.
That
I
becomes an issue.
don't see ZBAs having jurisdiction. I
I would be more than
respectfully
happy,
disagree.
Mr. McDonald, I would be more than happy to submit, if you wanna push this out for 30 days, I will submit an extensive memorandum of understanding on the jurisdiction of this ZBA to hear this issue. I have no problem doing that, because I feel that confidently on why we're here today. Okay, there's been less than 30 days from the filing of this appeal from the request of enforcement of the issues that the chairman has recognized exist. Yeah, I have serious issues also with the building enforcement officer now saying that he understands that there's an issue and that he made a mistake, because in 2011, when attorneys contacted him, he said, no, there's no mistake. In 2012, when attorneys contacted him, he said, no, there's no mistake. He knew. Even now, in 2014, when I contacted him, he said, 30 foot and 15-foot setbacks are fine for this area. But he just came in here today and said, I was wrong. And I knew I was wrong shortly after the building had already been erected.
We understand that you don't agree with what the process was and what's happening, and there's an argument of what's going on here, but you still haven't told us what's the remedy that you want? What are you seeking?
That's was my next question.
That's a remedy that would have to be, there's gonna be.
Well, you have something in mind. What is it? There's gotta be something that you're looking for.
The only way that we can figure to
Other
to
than
put the
arguing
setbacks
back
is
and
for
forth.
them to remedy the building, to change the building to conform with the setbacks, and or a variance if they come in front of the zoning board and it's properly
So the remedy
notified.
is for him to take 15 feet off of the existing building. That's what you're looking for.
Why did your clients wait 4 years to come?
The clients have
before
been
this?
contacting the board, the zoning enforcement officer, since 2011, December of 2011.
Yeah, but they never come to the board.
Why didn't they appeal in
I-
2011?
I could not even
I've got a
speak.
letter here dated the 10th, which in 2010, which is what I was making reference to earlier, and it just didn't, it didn't, excuse me. No, we're dealing with another issue here, please. So it did, it was the other gentleman and Greenwood, it was, it begins
It's
with.
Michael Tardy
Yeah.
and Rick Greenwood, and I
Mr. Tardy
apologize
is
that
the
he had.
And that was, that letter was in 2010.
Correct,
We're in 2014,
Right.
so 4 years later.
right. And the
Now-
building, but the building was still erected at that point, to the point that it's
But at
erected
that
now.
point, it was closer than, it was a year later.
So the tear down in 2010 would be any different than a tear.
I'm not saying about Hannah, I'm just saying that it was closer than 4 years henceforth to come in and say, hey, the
I had
building,
talked to
you know,
him.
is an issue.
Yeah.
I had
Hold on,
talked to him.
excuse me. You gotta be recognized, right? we'll get to
And
it.
they can absolutely speak, I mean, they're the
Yeah.
ones who've been going through this for years.
Yeah, but no, but what I'm saying, when we first had the discussion, I said,
Right.
I've heard about this,
Oh,
but it was a
absolutely.
different person
Right.
in 2010. And what the person called me, and I said, listen, what you have to do, you have to pay the fee, which was then a lot more, and come before the board, which didn't happen.
Right.
Okay, that didn't happen. Now, 4 years later, the fee went down, we tried to make it more equitable for people, and now you're here before the board, but it's 4 years later. And I agree
I
with-
can't
I
speak
agree
as
with-
what the
with
prior
John-
attorneys
with
had done,
Dan,
so-
and-
Well, the thing is this, that the permit was issued, the use is the same as what was on the permit, and the building hasn't been altered since it was built. That's the issue, okay? Now, if somehow since the day of the permit it morphed into something else, then that may be a live issue, but it's not. Okay? And for that reason, you have to appeal the permit, because the use has been continuous, from everything we've heard.
Yeah, go ahead.
And the timeline to appeal the permit is 30 days.
Yeah.
Well,
You can take that before a judge, that's my
Yeah,
opinion.
okay,
I'll
Jim.
do that in 30 days.
When we held a site plan review, believe me, if someone walks in there and starts complaining about what's going on and everything else, planning board is immediately break on. All stop. We wanna know everything. At that point, we're gonna go back to the zoning board. We're gonna go to the building inspector.
And this-
Nothing happened like that.
And that meeting was after the abutters were notified
Yes.
in writing, the certified mail.
Yes.
Did
I
any
mean,
of you butters?
I mean, if somebody's gonna be digging a hole next to me and putting in a building and everything, and I don't know about it, I wanna be on the phone to my lawyer right then and there.
Yeah.
I'm not gonna waste a second. I
Jim,
wanna know something.
you're right in that regard. I mean, I just had enough experience to know that the minute either you cut a tree or you dig a hole, your butters know about it, and if there's a concern, they're gonna call town hall and find out what's going on. That's just a given, period.
And I'm betting anything, I mean, I think it didn't go up overnight.
No, that Morton building probably didn't get ordered until after the
Sure.
permit was obtained, because you're not gonna order a building that size without having the necessary documentation in hand. That's been my experience in the past, and I've issued permits in the past for several Morton buildings, so I know how that procedure works.
We know how imperfect we are in this town,
You know,
and we know
You know the
we
procedure, don't
try
you?
to tighten up.
okay, either you sit there and be quiet, or you
Sometimes
leave,
it
that's
doesn't
it.
happen.
We understand each other? As simple as that. Go ahead, the gentleman in the purple shirt.
My name's Joe Ryan, I'm on a butter on 2 streets. On Salem and Sewell Street, I own 2 acres. On Nelson Street, I own 2 lots above it. I have no problem with nothing there at all. The day he went in there, he told me what he's gonna do. I was notified, registered mail, everything, for everything. I watched him do it. I watched Mr. Skeeter go down and inspect it. And I watched the load of shit they took out of there, it was there. And I mean loads. I have no problem with it.
Now, you're an adjacent abutter? You own land?
I own land on Sewell Street,
Okay,
2
does-
acres.
Does that
Sewell
abut
and
this
Salem
property?
Street.
You
He
abut-
uses Sewell Street to go in out every day. And I also own 2 lots on Nelson Street above his garage.
So
He
you
uses
directly
that.
abut him, that's what he's
Yeah,
asking.
I'm
I'm a
actually-
butter on 2 streets.
You're a direct abutter to the gentleman?
On the, no,
On
not
Nelson
correct.
Street?
There's a lot in between them, both of them.
Okay, that's what I was trying to find out. Go ahead, yep. Your
Brad
name-
Legals, I have,
And your name?
Brad Legals, I'm the owner of the building.
Okay, yep.
The original, I have the original, side lot lines, front and rear. So when we come in here tonight, and I'm told something different, and looking for a variance, this is what I have on June 28th in 2010, in writing, so I'd like to bring it up and show your attention.
Yeah, do you have 905 out of our ordinance?
It's a letter from.
Is that
It's a letter from the building inspector.
Yeah, I see that right here. I got that letter right here. Well, unfortunately, let me just tell you, this is an unfortunate, and I can tell you, I always felt bad, and it only happened a couple of times, but as an inspector, being human, sometimes we make a mistake. And unfortunately, even if you make a mistake, it doesn't make it right. And in this particular case, the setbacks are wrong, and that letter, even though it says that, the ordinance says 50 and 25. So the letter is an error, and you can't make you can't, the building inspector can't change those numbers, period.
That supersedes that.
Yeah.
That's what he's trying to say.
So the fact is, the setbacks for your building are 50 feet from the right of way and 25 feet from the side.
So 4 year later,
Doesn't matter, I guess it could be 10 years later, because any time, you cannot have a legal setback if it's in violation of the ordinance. And the fact that the inspector did it is, he's not the first person, won't be the last person to do it. I can also say in the 30 years that I issued permits, never did, but I did some other things that weren't exactly the code that I caught later on, and it's unfortunate, but because of the nature of the business, as being a building inspector and dealing with so many facets of the construction process, mistakes happen. And this, I'm sure what he probably thought was that in a residential zone, those were the numbers, inadvertently, someone might have caught him on the phone, might have been talking to someone else interrupted him, came back to it, and said, oh, but, and this happens, and in this particular case, he quoted you residential zone setbacks when it should have been commercial zone setbacks. Those can't be changed unless you get remedy.
So we're back to what we originally, basically, we're going around the table like Mr. Wood just said here. We can be here all night. You have edged in your mind what you wanna do and where you wanna go with it. The crowd, the building owner, the building inspector, everyone has spoken. I think at this point in time, do you wanna take your 30 days, go back, reconvene, come back and see us? I mean, me personally, like I said earlier, I can't emphasize it enough. We can beat this thing, and we can beat it. Can we all come to common ground somewhere? What does Mr. Greenman wanna do? I mean, I think our chairman has already stated there was an issue. It's clear, he's made it clear, the building inspector made it clear. It was a mistake on the building.
May I speak?
Sure.
Your name, sir?
Mr. Chairman?
My name is Richard Greenwood. I'm not a main abutter, but I am a butter. My biggest issue is, Mr. McCabe says there was a problem with, we used to get along. We did get along. Parking and whatnot. That really isn't the issue. The issue is, he's been in there for 4 years, running the business out of there for 4 years, with no occupancy permit, no business permit, nothing. So, I mean, that's the biggest issue. I've been in business there for 30 years, I have to have a permit. No matter what I do, I have to have a permit for anything I do there. And I'm sure Mr. Ryan can tell you that. But, so the biggest problem is, like I said, he's been there for 4 years now. This has been in court, not in court, but it's been through lawyers for 4 years. It's been going on for 4 years. I don't know my legal rights of what you can do, how you can stop this or not. The lawyers, that's the lawyer's job.
Well, I think it's clear that with disclosure periods, I'll just say that this gentleman, once removed, is an attorney.
And on the permit, okay, there's an appeal period, I get it.
Yeah, I agree with you on that.
All right, and it's there for a reason, because people make mistakes, and the statute anticipates that building inspectors will make mistakes, okay? But there's an appeal period, and there's a cure period, and that's lapsed, okay? It's not indefinite, okay? So if you're gonna cry foul or something, you get your 30-day period, you got notice. It's not some mistakes of the building inspector under the statute that won't stand. I don't interpret that setbacks are somehow excluded from interpretive mistakes from the building inspector or any other bylaws or building code violations. Certainly, if there were safety issues, fire issues that have to be rectified. But once you build that building, the setbacks are established, they're set in stone, set in concrete, set in something. And, you had a period to appeal that at the review plan or at the issuance of the permit. And it should have been stopped, or at least there should have been under the law, there is a duty of inquiry. That is in the case law. I've read case law, I'm an attorney. And there are arguments, there's always arguments back and forth, and that's how lawyers are in business. There's multiple interpretations, and I understand attorneys advocate for their clients, but I'm trying to be impartial on this. I am impartial on it, and my interpretation of that we don't have jurisdiction to an untimely appeal from a building permit beyond 30 days. That's
I agree with you. Now, listen, Mr. Biewen, when it went before the planning board, did you attend that meeting?
No, I did not.
Okay, and why would you not have attended?
I don't believe I was notified.
Cause you're not a direct abutter, is
He's
that?
in a direct about, he's in a direct about.
But usually, if you go for a special permit for zoning, you usually have, you're notified.
Well,
Registered mail, or
the gentleman
certified
from
mail.
the planning board just said the
you
butters
like to
were
read 'em?
notified. There you go, you
Would
got.
you like them all right here?
Bring it right up, yeah, please.
We did get notified about the
Hold
telephone.
on, hold on, let me just see.
Sandra Tardy, 3 Nelson, I don't know if you want to.
Okay, I'll read them for the record, thank you. Sandra Tardy, 3 Nelson Drive.
Is there a date on those? I'm sorry.
Yes,
Chairman.
there is.
What's the date on that?
The date is 6/15/2010. Richard Greenwood. 6/15/2010, notified.
May I speak?
No, I'm gonna finish all over first.
All right.
6/15/2010, Todd Williams, 861 Salem Street. 6/15, there's 857 Salem Street, and it might be Robert Curtin, Jr. This is the type of documentation that we wanted earlier this evening, which probably would have settled a lot of this earlier. The fact of the matter is, Skylar Heights Realty at 727 Skylar Drive, Groveland, something LLC at 8587 Boston Street. 833 Salem Street, Groveland. These are all 6/15. And then there's a Joseph Ryan at 865 Salem Street. These are all 6/15. Now, this is the time that you should have appealed, clearly. You were notified, here's the certified mail, you were notified. That was the time you should have appealed the use and whatever concerns you had relative to that particular building project. And so I agree wholeheartedly with, I hate to admit this on camera, with an attorney here, that that was your appeal, and you blew it. So it's my contention that the only issue that the board could have any jurisdiction over, and in fact, like I said, the only time I've ever seen setbacks an issue, and I've seen all kinds of them, is when the person, number one, wants to refinance or sell, because that's gonna come up when the person goes out and does a mortgage survey. Those issues are gonna arise, and there's gonna be an issue at that particular time, and I've seen it numerous times. But I think the proof here is in the certified mail receipt that you were notified, and you didn't go.
I believe that was for putting the telephone poles in the road. That's the only time I was notified.
What was the date of the planning board meeting that month? Do we know?
The letter is from Cabinet Engineering on June 23rd. I think the planning board granted special permit on the 30th of June.
And then it would have been out,
Granted on 30th of June, so I'm not sure if
they would have
back.
been out probably 10 days before,
That was 15 days.
15 days before,
So,
yeah.
does that fall usually within the timeline of the planning board, that those would
15
have
days
gotten
before.
about 15
Right,
days ahead of time? Do you typically meet at
I'm
the
going
other
by
one?
memory, and it was, I believe.
Was that the letter that went with it?
Yep, that's the letter that went with it.
July 15th, 2010, I believe it was.
So that was the date of your meeting?
The polls didn't go in until a long time after.
The building was already up.
Building was already up.
This is the notice that you got, which was attached to them. It's a notification to abutters under the terms of Town of Groveland zoning regulations. In accordance with Town of zoning bylaws, you are hereby notified of the following. The name of the applicant is Brad Legals. The applicant has filed a special permit application with the municipality of Groveland seeking permission to construct a 30 by 60 single-story garage, and is seeking a special permit in accordance with section 1700 of the Town of Groveland zoning regulations, section 108 site plan review. The address of the lot where the activity is proposed, 16 Nelson Street. Copies of the proposed plans may be obtained by contacting Steve Sawyer of Oak Engineering between hours of 8 a.m. and 5 p.m. Monday through Friday. Notice of the public hearing, including its date, time, and place, will be published in at least 5 days in advance of, and the Lawrence Eagle Tribune. The date of the hearing is scheduled Tuesday, June 29th, 2010 at 7:45 p.m. in Groveland Town Hall. And this is the letter that was attached to these. So I think clearly you were notified. And if, even if this wasn't, like I said before, the moment that first excavator hit the ground, you knew something was going in. And it was incumbent upon you at that particular time to come down and say, hey, what's going on? That didn't happen.
We do have other issues.
Yeah, I understand.
The issues are, he's going up and down there with oil trucks, the road's not wide enough, this was never addressed.
I think, let me just ask the gentleman from the planning board again, one more time. Jim, for the record, I asked you before, I asked you again. When the applicant came before you, and with his site plan, did the planning board approve that site plan as submitted?
Yes.
No changes?
So if you had concerns about the trucks going up this road that wasn't wide enough, that was the time to address it, not 4 years later. I'm not sure how clear we can be here.
I mean, there's no turnaround for fire apparatus
Listen,
down there.
I got a letter from the fire department, no problem, but all this would have been addressed at the planning board meeting that you could have gone to when you were notified to go and didn't go. So I'm not sure, you know, what do you think the board's gonna do 4 years later?
This has been going on for 4 years, pretty much.
You had a chance, you were notified of a meeting that you should have attended if you had concerns regarding, number one, the use, and the road, and all the issues that you're coming to the board 4 years later on. The time to do that was when you were notified to go to the meeting 4 years ago.
Okay, so pretty much what we're trying to say here is that it's okay for him to have a business there, run a business illegally.
It's not,
4 years.
it's not illegal.
And there's nothing being done about it. He should have had a cease and desist.
Okay.
That business should have never been run. He doesn't have a business permit, he don't have an occupancy permit, and he's running a full-time business out of it.
Storage.
Yeah, okay. Well, it's an industrial zone, number one, okay? He went before the board, the planning board, to obtain approval for a site plan to store 2 trucks, oil trucks in an industrial zone. The fire department reviewed it, the water district reviewed it, engineer reviewed it. The building was constructed to contain any spills that might occur, and all those issues were addressed, when? At the meeting on June 29th, 2010. Now we're here July 2nd in 2014 complaining about something that you should have
That's
addressed.
irrelevant. That's irrelevant.
No, it is not
Where's his
irrelevant.
business permits? He has to have a business permit and go to run a
It was
business.
a permitted use, and the fact is, he probably should have come before the Board of Appeals, which he should have, and he didn't, but he went with the more important issue was the aquifer protection, which is what we want to protect in town, obviously, and you were notified and didn't go. It's as simple as that. This is black and white. I don't see any issues. Go ahead, Pat, what do you got?
I just want to, I don't believe you have this document of the appeals. It's exactly what we're talking about right now.
so that after the, which is the same thing happens with the Board of Appeals.
Right.
zoning board. After the meeting, there was, what do you?
Copy of the decision?
The decision, yeah, there you go.
Exactly.
There was a copy of the decision that was filed, and this is the documentation that was filed with the town.
Exactly.
So, even at that point here, okay, even at this point right here, which was June 30th, 2010, guess what happens in June 30th, 2010?
No appeal.
There's a 30-day appeal
Right.
from this date here. Did that happen?
No.
Did you appeal in 30 days?
No, I didn't appeal.
Okay. Well, then, you know, that's why we have rules and regulations,
Right.
right, Dan?
The rules apply equally
That's right.
to all.
Thank you,
Mr.
Chair.
Chair,
So-
what
You're
about
welcome.
section 900 for rules and regulation compliance? They haven't been met yet.
So just to make it clear.
Well, I
if the
think
board's-
yeah, sure. I think we've, beat that horse. I'm ready to move on.
I just like, wanna say something,
Go ahead.
I just like what you said about how people made mistakes, because you had a former chair on this board who allowed an in-law apartment detached from the house, and ever since then, you've had people complaining, because that one person allowed that detached thing, now you have people coming in, you're supposed to have it attached
Yeah.
to the house.
We were talking about that. Anyone else want to speak that
I
hasn't
just wanna
spoken?
speak very quick, so it is.
Hold on one second. There's a gentleman that hasn't spoken.
I didn't ask.
That didn't speak.
Did you speak before? Anyone
No, I
else?
didn't
Go
speak.
ahead. What's your name, sir?
Dick Becker, and I'm a potter, right beside it. And I didn't have any problem with what they were doing, but I have some concerns because it's wetlands also at times, because the gentleman had a garden there. And it abuts my piece of property, which I have 8 acres. And so I don't want it, a spill coming over and tainting ours. And I don't know whether something can be done about that.
Well, that was addressed at the planning board meeting. Now, you got notified. Did you go to the meeting?
No, I didn't go because I was taking care of my mother.
Okay.
That's why. I mean, I was her caretaker. So I was in the house with her at night, so I couldn't.
Well.
But I'm just
then
concerned if
what-
there's
and
something
let
that can
me
be
just
done.
finish. If this happens again and you can't attend, we have what we call written notification. If you have concerns, you could write a letter basing your concerns at that particular time, and then they will address those concerns at the meeting. This happens out of town on vacation, death in the family, taking care of your mother, can't make it, you send a letter, and today, we could email, text, you could do all kinds of things
Okay, but I-
to
I'm
notify
just-
if you got some concerns. But that's 4 years ago.
I understand
You
that.
know,
But
and the planning board feels that they address those issues. Now, if you have knowledge that things are in violation of the approval of the planning board's approval, and you have direct knowledge that the gentleman is in violation of that approval process, then you can appeal that to the zoning administrator for relief. But you have to have proof that he's in violation of the approval by the planning board. And I guess I would suggest that you should probably get a copy of the approval process,
I can look at that.
approval conditions, so that you could review them, and if he's in violation, then you could proceed with that particular issue with the zoning administrator. Go ahead, you had another thing.
Just as a review, so it is, the board is taking the position that if an abutter was notified for the planning board meeting, despite whether the property was giving a proper building permit, despite whether they went in front of the zoning board of appeals for a special permit, and despite mistake made by the building inspector, that the setbacks are incorrect and wrong, continuing to this day. A person who is aggrieved today cannot request, if they had been previously notified of a meeting that happened on the same property, if somebody aggrieved requests that enforcement be sought by the building enforcement officer, they do not have standing if they were previously notified in the planning board meeting and did not attend. I would just want to clarify.
That would be my, I'm not a judge, but that would be my thought.
Well, I just happen to disagree.
I understand, that's why
And we have
we
a
have an
right to.
attorney.
We haven't
That's why
put
we have an
it
attorney.
we haven't put it to a vote yet.
Yeah, no, and I'm only one person, I'm
I'm just
not-
trying to clarify
I'm
because
not
there was a lot of
voting, I'm only one vote. Go ahead. Sir.
Bob O'Hanley,
Bob
planning board. To get back to the drainage, we called in conservation, there was a ditch right across the road. Conservation figured out what size pipe they needed to alleviate any buildup on Mr. Legal's land that goes across the road and out. So they were into the action with the site plan review along with the water and sewer.
The other part is you can't dump any liquid on someone else's land. I mean, you just go right to conservation at that point, you know, and request a hearing. And that will have to get rectified at some point in time.
If there's an issue.
There are things that can still be done if they need to be done.
Yeah.
There are avenues.
That's right. But that's if they're in violation of your approval.
Well, no, I mean, if something changes.
Well, that's right. Well,
Later on.
Yeah, that's what I mean, yeah.
It goes on to someone's land, they can go right
Well,
to
that's right.
conservation.
Yeah. But
They have that, they have that right.
But that's why I said the gentleman should get a copy of what was approved, and if what's being done at the site has exceeded those regulations, then he has an issue that they could take to the zoning administrator and try to rectify those issues. Bill, you had a question?
No, kinda going off what Jim just said, the way I feel about it, there's boards here in town, and if there's a problem or a complaint right now, I would hope the parties could bring it to the board, which I'm sure that they're doing tonight. But if there's new ongoing complaints, you would, like, the gentleman said about conservation, like, you would think he would've went to conservation as well, you know what I'm saying?
Yeah, sorry, sidebar.
I just don't wanna see the town spending legal fees when they don't have to.
I don't either, I agree with you 100%, but can we
And
come
that's
to
what
common ground with
sounds
this?
like-
I mean,
It's not sounding very good here tonight. When
well,
you
I'm
have
just
a
saying,
6-year
if
statute
you
of
find common
limitations
ground,
on
or
use
you,
of
if
town
you're,
structure, there's a problem here. And that's why I don't wanna see the town tied up in one. We were sued and won. Previous board granted the same special permit wrongfully so before town council answered the proper questions. One town's council answered the questions, and the applicant came back to do the special permit, again, the same permit, because the initial one had expired. Took us to court and lost, and it's all in there, A, B, C, all the way, the whole alphabet, and if you read it carefully, please make the right decision for the town. Now, I don't care what goes on in the buildings, I never have. All I care about is the protection of our water supply, traffic, all that type of issues. That's all, never
Okay,
more
I'm
than that.
gonna close the public hearing. One more, you've spoken, I'm gonna make a motion, I'm all set.
Yeah, okay.
Listen, I'm gonna make a motion that the applicant, well, the applicant, not the applicant, the owner, Mr. Legal, has a duty under section 903 to obtain and I'll just read this for the record. No industrial or manufacturing use or business use shall be expanded beyond the limits set forth by the zoning board of appeals or by other means without issuance of a special permit by the zoning board of appeals after a public hearing. So it appears to me that in order for there to be an expanded use, then he has to have a use first a use has to be granted by the Board of Appeals. So in my motion is that Mr. Legal has to bring a plan before the ZBA for a special permit to operate his business at that location. That's my first part of the motion. And secondly, the setbacks which were inadvertently given to him by the building inspector of 30 and 15 has to be rectified or some type of relief to the point where the setbacks have to be 50 feet from the private or public right-of-way and 25 feet from the side. That's my motion. Do I have a second?
Second.
Is it
Any
discussion on the
discussion?
motion?
Any discussion?
Yes.
Not from the board. I told you, hearing's clear. It's been closed. Okay? Close hearing. Any discussion?
Can you clarify the business at that location? Is that beyond the already permitted use of the storage?
Well, I think that we.
Because he already was granted a permit for storage.
I think, sometimes people come in after the fact and get approvals for things. I think he needs to get an approval for the use that was approved by the, whatever he went to the planning board with. And then if he gets the use approved by the zoning board of appeals, then if he expands that use, then gentlemen like this, or anyone else who has an issue of an expanded use that was already previously approved by the planning board, then the board would have jurisdiction.
My position is that the planning board's approval is now, their appeal is time barred by 30 days.
No, we're not appealing there. What? No, let me read it again.
Read it again.
I make a motion that the the owner, Mr. Legal, needs to come before the zoning board of appeals to satisfy section 903, which states no industrial or manufacturing use or business use shall be expanded beyond limits set forth by the zoning board of appeals, or by any other means, comma, without issuance of a special permit by the zoning board of appeals after a public hearing. So this is no different than if someone, well, we've had them out on 967, I think it is, out there, the people come in and, oh, well, we run a business, we didn't know we had to have this. So they come in after the fact to get permission to run the dance studio or the daycare center. So what he has to do, and then at that point, when he comes back, we're gonna review what the planning board reviewed, and he can't, when he comes in, we're not gonna approve anything that exceeds what the planning board exceeds. But at that point, then, if he exceeds that, then he'd be in violation of 903, which then would go to the zoning administrator.
I think it needs to be determined whether or not he's expanded use beyond just storage of oil trucks.
Well, that will come up in the public hearing.
If he hasn't, we don't have jurisdiction to.
Well,
to
no,
do
I
that.
think we do. I think we do, and the reason I say we do is that it's like all the issues, the dance studio, the liquor store, the dance, and the beds down here, and all these that come in after the fact. Put your thinking cap on and just think a minute. No industrial or manufacturing use or business use shall be expanded beyond the limits set forth by the zoning board of appeals. Okay?
I understand that.
Okay. Or by any other means, comma, which probably could mean planable, without the issuance of a special permit by the zoning board of appeals after a public hearing. So
I
he
understand
really
that.
needs to get a special permit from the zoning board of appeals so that we can find out, set the bar to say, okay, this is what you got the approval for. And then if you exceed that, now there's issues that can go to the zoning administrator to review.
Step one, step two.
Exactly, yeah, step one, step two. And then secondly, I think he has to resolve the issue of the setbacks. Like I said,
I disagree with that.
well, yeah, I understand, but that,
But that will be for the hearing on the.
yeah, I mean, I just think that I just know from experience that setbacks, even if you make a mistake, it doesn't make it right. Nowhere in the book does it say that.
It doesn't make it right, but you have to make it right within 30 days.
Well, I don't think so.
Agreed.
I don't
However,
know.
They failed to do that.
right, but in the bylaw, it states that in an industrial zone, if you're gonna
Mass
do that.
General Law, Chapter 48 supersedes the local, it has procedural rules in place you have to follow,
I understand.
Massachusetts statutes.
I get that.
So when there's an aggrieved party, they have a right to appeal, they have rights, okay? But they have to exercise those rights timely, and when they don't, they waive those rights. And the mistakes of the permitting process stand.
I don't think so. I disagree with you.
I believe the case law is strong on it.
Yeah, well.
Otherwise, you have people coming back with, oh, another thing, you didn't do this, and oh,
Well,
we flip over this rock, and oh, you
we've
didn't do that.
We've had people come back with setback
And
issues
it never ends.
years later. And it happens when, like I said, when you either refinance or try to sell it, and there's a survey done that says, oh, wait a minute, these don't meet the setbacks.
We just had one, not that long ago,
Yeah.
where it was an in-law that was in there forever
If
and
the,
never
if
got
the,
approval.
if the setbacks
And they came in after the fact. and
was
said, hey,
approved by the building inspector, and the zoning enforcement officer, it's done. After
No,
But
no,
without
no.
that, they have no, they're not.
Yeah, but, see, I disagree with you. Like I said, the unfortunate thing is, even if you make a mistake, it doesn't make it right. You can't.
Mistakes out of it.
Yeah, mistakes doesn't.
What
don't
makes,
put-
what makes it right under the statute is, once the appeal period lapses, the aggrieved parties have waived, and that makes it right. You waive your
I
rights
see
to
that, but the
appeal
setback
at
I'm
is
any
putting the
time.
aggrieved parties aside.
Yeah.
That whole issue is sidebar.
People that have
Right.
standing.
No, what I'm talking about is this, look, Never mind what
Our-
you said, pardon me.
Zoning-
It's fine.
I can read, you showed it to me, all right?
I understand, I'm just saying that they should be in compliance and get it after the fact like other people do, so that we have
If
something
the
to work with
building
later.
inspector makes
not
a
in
mistake,
compliance.
and there were mistakes made, you have to timely appeal it or you're time barred, and that's just,
Yeah, I disagree with
So-
that.
I disagree
But-
with
but-
that. That's-
you're time barred.
That's bull.
And
I
the
disagree
courts
with
lack jurisdiction, the SJC lacks
Oh, let's
jurisdiction.
let that come up to the board. Anyways, my second part of it was that that under section, 90.
And keep the swears down, all right? You know, please. Keep, yeah, that's be what? Please, keep it professional.
It's actually better to right a ship than let it sink. So, I think you're on the right track with that one.
So-
I would,
Is the public hearing closed?
Yes.
Okay, so,
Yeah.
can I just, Mr. Chair, can I just make a point of order about your motion?
No. Thank you.
I think you,
Thank you.
Sure.
So, any other, Mike, you got any questions?
No, I understand.
Bill?
No.
No, I agree with what you're saying, and that will come up at the hearing, or when they come up, all your issues will be addressed at that particular time. Maybe at that point, we're not, but I think we are. And it's the same type of thing, is that no matter how long you go, the only one that can change setbacks are the planning board would make recommendation to the selectmen, bring it to the town meeting, and have a vote.
Then what's the purpose of the statute of limitations?
Well, the statute of limitations, but we're talking two different things here. We're talking about,
Are we?
yeah, well, the setbacks are always there. The building can be moved, torn down, the business could be shut down, could be cut back to, if they expanded use further than the approval. But the fact that setbacks were issued wrong doesn't make it right.
Dan,
You can't make a wrong right.
Dan, hold on.
Go ahead.
Go ahead.
Every business that is gonna open up in Groveland, is gonna come to Groveland, has to come before the ZBA.
Exactly.
Am I correct?
Yes.
So, I think Mr. Friel said the same thing. I think we're on the right avenue
Right.
to
He,
let,
it's just, he put the cart before the horse.
exactly.
So now you gotta straighten
Okay,
out the
so
horse.
I think we're, let's have a vote. All those in favor of my motion?
Aye.
Opposed?
Opposed?
Opposed.
3-2. Carries.
Four.
Wait, a minute,
No,
what was the count? Say that one more
What
time?
is it? I thought, how'd you vote?
Yes,
Yes.
to have them come in and
Yeah.
try to
okay.
rectify it
Four-
with
four-
us.
4-1, yeah, 4-1.
Yeah.
We're all set. 4-1. You're right. Now, I thought, 4-1,
I think Michael was putting up two hands.
yeah, for my motion, and, did you understand that, the motion, Mr. Ligo? Legal, excuse me?
Yeah, so what do I have to do now?
You have to come before the zoning board of appeals to legalize the business with a special permit, and you gotta try to seek relief on your setbacks. And sooner rather than later on that, but you can check with Julie as to what the time frame is. Obviously, you're probably gonna need to get some, I would think a couple months, by September, we should be on the agenda for these items.
the time frame has to be set by the board as part of the order.
Yeah, well, and.
And it still needs a decision filed with the town clerk.
Let me make an amendment to that, to say that it should be September, what's the date?
September 3rd.
September 3rd meeting, by the September 3rd meeting. Any second? Mike, all approved?
I'm
Okay.
opposed.
So, okay, one opposed, yeah. Okay, so we're all set, next item, we're all set, thank you.
Thank you very much for your time, I appreciate it.
Yep, okay, accept the minutes, let's see, the minutes. Okay. Which one? Oh,
Okay, down there.
do you understand what happened?
Yeah.
All right. Thank you for coming this evening.
Thank you, Chairman.
Thank you, okay,
Appreciate it.
thank you. You can-
I haven't officially.
I've seen you around.
I'm from here.
You looked familiar when I came in. Yeah.
I'm from here, so.
Hi, Kathy Francis.
Attorney.
Yeah. You shaking hands with him?
We usually just whack
Yeah, we
it.
whack it, yeah.
That's okay, I usually just smile.
Thank you.
Bye, guys, have a great night.
So, we're talking about the minutes of May 7th. How about, we have some other issues. You're right, yeah. Yeah, it's gonna be a little bit contentious. Do you have invoices? Everyone here, was at the meeting at the Blue Book?
Yes.
Yes.
Yes,
September 28th is the magic day that we need to review that.
yes, no, August 28th. You said September, it's August. No, they need to get it to town council by
Yeah, I
September
think,
1st.
yeah, it was the end of August.
August, okay, I got it written down in my book.
We have 2 months.
Okay.
We had originally thought 1, but then vacations extended it to 2.
Okay. Okay, so we got, let's see.
Mr. Legals, if you wanna come in, for the September 3rd, to have a hearing on September 3rd, you need to make sure that you file the application by August 10th.
Do you have an application to file?
I don't have one.
Town clerk.
Town clerk's
Town
gonna,
clerk has it.
you need a special permit and also a variance, so variance request. She has both of those forms.
Trying to get it online, but I'm not sure it's happened yet.
Yeah,
Special
we're,
permit and application for,
Variance.
an application variance, yeah, we're working on getting those online.
Do we issue the ban?
She's not open tomorrow, so you might wanna check back next week.
And then we have the,
so I come over with a lawyer, counsel
yeah.
for this?
You have to have another hearing.
What's that? Yeah,
Prepare myself for counsel.
authority.
that's up to you. So I make a motion to approve the minutes of May 7th, 2014. Second?
Second.
Second by Kathy. Any discussion? All those in favor? Approved. 5-0. We've got a couple of, I guess out of,
Brad, you wanna come here a minute?
I guess out of other business, the only thing that we should be discussing is the new zoning ordinance, and try to, maybe in August, we'll try to discuss that collectively. I've had a chance to look at it, Bill, it looks pretty negative to me. There's a lot of NPs there, or NAs, and they're not allowed, and I'm not sure that,
Not permitted.
yeah, NP, yeah, I'm not sure, you know, where.
But at least we have the right to go look at it and make our decision and go back before them.
Yeah.
And I think that's the right process.
Yeah,
You know what I mean?
yeah,
I do.
yeah.
Right.
But it just, you know, in my cursory review of it, it looked like an awful lot of non-permitted uses, so. And as I said, the fact that the type of government that we have here is a town meeting, there are a lot of gray areas that can't get, you know, you can't get to for a long time. So if we come up with those gray areas, it's not gonna be, it'll be a lot of unhappy campers, and it may be something that you want anyways, so. We're all set. Did you got my motion, didn't you?
Bill,
on
did you sign
tape,
this
so-
one for me,
Yeah,
please?
so,
I don't know if you have it written down or.
well, I don't, I just copied some stuff that I read in the book.
I know.
905,
I told
and
him.
then, you know, that you have to seek relief from 905, and then 901.
I have written down,
You just voted
we feel
otherwise.
motion that Mr. Legals has
Now
the
he's
duty
gotta
to
go get a
obtain to
variance
satisfy
and-
section 903 to bring plans
Yeah,
to operate his business, and there's an extension.
yeah,
And setbacks in the industrial
Yeah.
zone or business shall be set back 50 feet from the adjacent right of way, and shall be at least 25 feet
submitted by September 3rd meeting. Okay, I'm gonna make a motion to approve the Eagle Tribune, amount of $214.20. Any discussion? Any
Second.
Kathy, any discussion? All those in favor? This is approved. And let's see, there's a Julie House Zoning Board of Appeals Administrative Assistant bill for $1,029.84. Make a motion to approve that. Any second?
Second.
Second. Any discussion? All those in favor? Okay, nothing else. Anyone got anything else on open discussion?
No.
Anything, Mike? Bill? Bill, by the way, good luck on that operation tomorrow.
Oh, thank you.
I do know people have had it, and I believe that the guy's right when he said you'll be going home.
I hope so.
Cross your fingers. What were we thinking of there?
Take a break, get some rest.
We need a motion to adjourn at 9:30.
Second.
Second, all those in favor?
Aye.
Thank you.
Hey, Joey?